Hi, I'm Greg Corombos. My guest at this time is Andrew C. McCarthy. He is a former Chief Assistant U.S. Attorney in the Southern District of New York. He's now a contributing editor and columnist at National Review Online, and he's also a Fox News Channel contributor. We want to get his thoughts on two stories today, primarily the decision of the Justice Department to drop the case against former National Security Advisor General Michael Flynn, and we'll also get his thoughts on a curious announcement from Ventura County, California, about who can stay in their own homes and who can't during this COVID crisis. And Andy, thanks so much for being with us.
Greg, great to be with you.
Well, the Justice Department has issued some language here. It says in court documents filed Thursday, the Justice Department is dropping the case, quote, after a considered review of all the facts and circumstances of this case, including newly discovered and disclosed information. Ultimately, the department concluded that Flynn's interview by the FBI in January 2017 was, quote, untethered to and unjustified by the FBI's counterintelligence investigation into Mr. Flynn, and that the interview was conducted without any legitimate investigative basis. And of course, this comes just a few days, Andy, after we got those notes where it seemed like the FBI investigators were either looking to have him confirm something they thought might be incriminating or else get him to lie. So what ultimately is happening here? How did this case fall apart?
Well, I think, Greg, probably the big thing in terms of why it fell apart was the change in Flynn's approach to it over time. He didn't really fight the case much at the beginning. There were whispers that we heard from his camp that his plea was explained by the fact that they had threatened to prosecute his son with a felony violation of the Foreign Agents Registration Act, and that he pled guilty for that reason, not because he really was guilty, but he did go into court not once but twice and plead guilty and seemed to be ready to go along with that result. But he did change lawyers at a certain point, decided to fight the case, decided that he shouldn't have pled guilty, that he wasn't guilty, and that he wanted his day in court at trial. And in the meantime, his lawyer, Sidney Powell, very vigorously challenged the Justice Department on its failure to disclose all kinds of exculpatory evidence, particularly about the circumstances of his FBI interview and the report that the FBI generated from that interview. All that stuff turned out to be, as the Justice Department suggests, problematic. But from DOJ's perspective, I think what they're highlighting is the fact that there was no underlying basis in terms of a crime or in terms of a valid counterintelligence basis for the Justice Department to investigate Flynn or to have conducted an interview with him, which the disclosures we've seen in recent days have confirmed was really a perjury trap type interview, and one that the FBI shouldn't have done, had no authority to do, and did outside of normal protocol, in the sense that if the FBI wants to grill a member of the president's staff, there's a protocol for that. You're supposed to go to the Justice Department, to the Attorney General, who then coordinates with the White House counsel so that the Justice Department knows exactly what the FBI wants to do and why, and so that any legitimate interest of the president and the administration can be protected, and also so that the subject that they want to interview can be told what his posture is in connection with the investigation and whether he needs counsel and the like. So the FBI skirted all those things in order to do an ambush interview on Flynn. It was clearly a perjury trap because they had a recording of the conversation they wanted to ask him about. They knew this was a conversation with the Russian ambassador, Sergei Kislyak. They knew that there had been no impropriety in that conversation because they had a recording of it, and they made a conscious decision not to play the recording for Flynn to refresh his recollection, but rather to pepper him with questions about this conversation that had happened weeks earlier, to see if he would basically repeat what was on the tape, which is not a normal way of going about an investigation. Even then, Greg, the agents who did the interview did not think that Flynn had intentionally misled them. There were some inconsistencies, but they thought, honestly, that was just failures of recollection. And the case sat there. The Comey FBI, for all the criticism that they come in for in this, never prosecuted Flynn or never sought to prosecute him. He wasn't prosecuted for almost, I guess it was 10 months later. And by then the Mueller team had come in. And now in the last few weeks, we have gotten some paper trail, which indicates that there was this commitment that was made not to prosecute his son, which the prosecutors on the case did not disclose to the court in connection with the plea, which under federal law you're supposed to do. And then we got a lot of very troubling disclosures, not only about the way the FBI went about conducting the interview, but the fact that they monkeyed around with what's known as the 302, which is the memorandum of interview that the FBI completes when it interviews a witness or otherwise collects evidence. So I think the Justice Department looked at all of that and just decided this thing stinks to high heaven and it's time to get out of here. So they have moved to dismiss the case.
Time slips away from me now. Was it last week when the notes came out? But whenever that was, I'm sure you saw other folks from at least some sort of legal training saying, oh, this is not what it seems like. Prosecutors go in all the time knowing what they already know and not letting the subject know. And so they're either trying to see if the person will lie about it or confirm what they already know. So while this looks bad, this is standard operating procedure. You're a prosecutor. You just explained why you don't believe it's standard operating procedure. So what's your response to their contention that it is?
Well, first of all, Greg, there's the obvious, right, which you don't need to be a lawyer to understand, which is if you're doing something that's completely legitimate, why not tell the Justice Department and the White House counsel that you want to have a conversation with Flynn? Why sneak around in a way that's outside the protocols if you know that what you're doing is perfectly appropriate? Secondly, you don't do a perjury trap to do a perjury trap. That is to say, you don't do something just to get somebody to lie for no reason connected to an investigation. I could try to make an arrangement where I get to talk to an organized crime figure, and if he's stupid enough to talk to me as the prosecutor, there's a good argument that you can make that I win either way. If he tells me what I want to know, I have more information. If he lies, I have something to squeeze him with, but that's only worth it to me because I know he's holding back on important information that could advance a criminal investigation. Here, they schemed to try to get Flynn to lie just to get him to lie. And when you're trying to get information, when you're engaged in the search for truth, which is what a counterintelligence or criminal investigation is supposed to be, then there's a very simple way that you go about that with someone like Flynn. You play the conversation for him and you say, what did you mean by this? What did you understand Kislyak to mean by that? That is, you go through it line by line with him to try to understand the conversation. That's not what they did here. They knew what was on the tape. They didn't need Flynn to interpret it for him. The only reason to ask him about the exact words that were used was in the hope that they would trip him up. And if you're doing something that's completely legitimate, why have the deputy director of the FBI call the guy before the agents go up there to soften him up and say, you want to get a lawyer involved in this, or you get the White House counsel or the White House chief of staff involved in this. It's just going to lengthen things, and who needs any of that? I mean, they basically discouraged him from notifying the people that he should notify. And I would note also, Greg, that if they were interviewing a gangbanger or an organized crime guy, they would have started the interview by giving the person his rights and making sure that that person understood whether he needed to talk to the FBI, the fact that he didn't need to talk to him, the fact that if he lied to them, it would be prosecutable in court, and that if he told them the truth or made any statements to them, that could be used against him in court. They would do that to a hardened criminal who was a subject in an investigation, but that's not a privilege the national security advisor got at the White House that day.
Real quick, final question on this topic, Andy, and that's that if you look at social media, and I know that's not the greatest cross-section of society to see what they're saying there, but it's either Flynn was railroaded, this was all about really an effort to get Trump, or on the other side, Bill Barr is Donald Trump's lackey, and this is all political from that perspective. So where are we right now in, you think, Americans believing justice is being done instead of some sort of political outcome?
It's a deeply divided country, Greg, and it seems certainly on social media that any decision is going to be instantly weighed for the politics of it rather than, what the underlying supporting documentation may say is what we ought to think about it. And I just think that's an unfortunate fact of life. But the Justice Department looked at this case. It's assigned to a federal judge who will, by the way, a federal judge will have to agree with the Justice Department to drop the case. So it's not like they're just acting on their own hook. The Attorney General in this instance assigned an independent prosecutor from outside Washington, not outside the government. He asked the U.S. Attorney from St. Louis, who had nothing to do with the case, but is a longtime not only federal prosecutor, but former FBI agent, to give this case a close examination, given the allegations that would be made about it, and determine whether things were done properly or not. And it's not like they just said to us things were done improperly. They've supported that to a fairly well with this paper trail that they've put out. So I don't really put much stock in the political arguments. I try, no matter how those arguments are made, to ask to see, what does the paper trail say here? And here, the paper trail is not good for the government. They would not have wanted to go into federal court to try this case if that's what they'd had to do.
All right, Andy, in our last few minutes here, let's quickly head out to Ventura County, California. It is a county with a population at last check of 846,000 people. And as of last check, meaning Tuesday, they had just under 600 COVID infections reported, which my math is not good, but that's a really small percentage. Nonetheless, they're still going forward with contact tracing, which of course means once people test positive, you figure out who they may have been around during the incubation period and find out if they're now testing positive as well. That's one thing, but according to Robert Levin, who is the chief health official for Ventura County, California, that's not where it's stopping. Here's what he had to say.
We also realize that as we find more contacts, some of the people we find are going to have trouble being isolated. For instance, if they live in a home where there's only one bathroom and there are 3 or 4 other people living there, and those people don't have COVID infection, we're not going to be able to keep the person in that home. Every person who we're isolating, for instance, needs to have their own bathroom. And so we'll be moving people like this into other kinds of housing that we have available.
So there you go, Andy. He's directly saying that if you only have one bathroom in your house, you test positive, or someone tests positive in your house and others don't, then the person that tests positive can't stay in their own home. I'm clearly not a lawyer, but in any way is that constitutional?
I don't think so, Greg. I think it sounds outrageous to me. Again, in every context, we have to remember that when the government tries to do something, even that it has a legitimate right to do, like try to prevent the spread of infectious disease, when it's dealing with your fundamental relationships and fundamental rights, it has to regulate in a way that is the least restrictive to your enjoyment of your liberty and your property and your rights. And, obviously there are easier and better ways to police the spread of infectious disease that would allow them to try to minimize it while at the same time allow families to remain together. I mean, it's just ridiculous. I mean, we're now at the point where they're telling some people they can't stay in their house, and they're telling all of Orange County that they can't go out of their house, apparently. So, they get you coming and going. But this, Greg, I must say, this goes to a deeper issue than the law and what the Constitution says, which is the political legitimacy of what these governments are trying to do. You cannot enforce social distancing and these other kinds of provisions they want to do, locking down the country, without buy-in from the public. You have to satisfy the public that what you're trying to do is legitimate and not overbearing and not being done for political or capricious reasons. And what I would be more worried about, as you described that scenario, I thought about what would happen if somebody told me that they were taking my son away, that he can't be in his own house with me, he's got to go someplace else with the state. Are you kidding me? And I have a feeling that we're going to see more and more of these demonstrations that we've seen throughout the country, and it's not going to get better if they continue to do these heavy-handed, ridiculous things.
Andy, that was one of my first reactions as well. I think it would be for just about any parent, or perhaps an adult with a parent in declining health, for example. But in any event, a very sobering way to end the conversation today. Thanks very much for your time and your insights, as always.
Thanks so much, Greg.
Andrew C. McCarthy, former Chief Assistant U.S. Attorney for the Southern District of New York, now a contributing editor and columnist at National Review Online. He's also a Fox News contributor. I'm Greg Corombos reporting for Radio America.